No, my lord, I have finished. My learned colleague, Mr. Ongoya, to say something.
My lords, my lady, I just have a few points to highlight. There's a question by Dr. Kamoto on misjoinder of his clients. Let me just make a simple point that to the limited question whether the DCJ can constitute this bench under Article 165 Clause 4 of the Constitution, the question of joinder, misjoinder, non-joinder is absolutely irrelevant. There's no bearing on that question completely, and that would be a straightforward answer to that issue. Mr. Kamoto also said that this court can sit on any day, at any time, continuously. Section 10, subsection 7 of the High Court Organization and Administration Act 2015 does not support his argument. That section provides, and I quote, the Chief Justice may, where necessary for the expedient and proper exercise of judicial authority, authorize the sitting of the court on any day or at any time. The sitting of this court on any day at any time requires express authority of the Chief Justice under Section 10, subsection 7 of the High Court Organization and Administration Act. My learned colleague, Mr. Nyamodi, made an important point, and I think I support that point. The Constitution says what it says, but it means what the court says. Very crucial point. The Constitution at Article 165, Clause 4, says who can constitute this bench. That is the Chief Justice. Can the DCJ also do it? Is that an administrative or a constitutional mandate? The jurisprudence by this court, as we have alluded to, is 3 cases. The Umtata case, the Kemri case, and the Leila Conchela case. The Umtata case and the Kemri case present that as a constitutional mandate of the Chief Justice. The Leila Conchela case at the High Court level presents it as an administrative function, but we now know that the Court of Appeal has found that to be an arguable point on appeal and has given a stay order on the strength of that arguability. The weight of that jurisprudence militates against finding that this is an administrative decision, as has been urged by my colleagues from the other side. Since I have only 5 minutes, an issue arose here, my lord, my lady. We tried to object, but we were told we will have a right of reply. Professor Agenda presented a piece of paper from his hand, claiming it's a memo from the Chief Justice. We sought clarification on where that paper has come from. First, his argument was it's in the portal. We sought to know in which case file in the portal that paper has come from and why it has no timestamp that is symptomatic of all documents that are lodged in the portal, and there was no clarity on that. He then said, Mr. Nyamodi will comment on it. Mr. Nyamodi stood, began, and concluded his submissions without commenting on it. He also told us it is in the file. Papers like this would find themselves in the file through affidavits. This evidentiary material. Again, we were not told which affidavit or which deponent filed on which day. We would therefore urge you that as you consider this matter, you take into account that we have not had a fair opportunity to treat this piece of evidence in its proper context because of the, with respect, woolly nature of the manner in which it has been presented before this court. I urge, my lords, that in view of the matters raised before you, this matter ought to finally clear the position of this court on the jurisprudence of Article 165, Clause 4 of the Constitution, to give it considered thought, and that you return this file back to the appropriate authority, the Chief Justice, to do that which is just and right, as per Article 165, Clause 4. In matters as fundamental as this, in a matter where we all agree that this is a defining moment for our country, we cannot afford to be casual about it. We cannot afford to be expedient about it. It's in matters where a question of principle arises. And of all the three organs of government, only one organ stands out for standing on principle, the judicial arm of government. All other arms of government stand on politics and policy, but principle is reserved for the judicial arm of government. We urge you to administer that principle and find that the applicants and their supporters before you have made out a case for you to down your tools in this matter on the strength of the manner in which you are constituted. I rest my case.